Hey, Ron.
All right.
All right, Mr. Boyle, would you like to delete your recording or be held in contempt of court?
I'm not deleting my recording.
Okay, all right, you're in contempt of court. You're sentenced 10 days in jail. Take him into custody and take him to jail. Today, you're going to get the court that you deserve. I do find you in direct contempt of court. You've already served a sentence of 10 days. Court hereby sentence you to 60 days in the county jail.
Welcome everybody back to my channel, Live BD. Like, share, and subscribe to Jason Boyle 3Me on YouTube, and let's help him get to 1,000 subscribers. May 29th, 2024, Oconee County Probate Judge Danny Singleton arrested Dr. Jason Boyle for allegedly violating the Supreme Court of South Carolina's administrative order on electronic devices. Even though no crime was committed and no law was broken, this judge sent him to the dungeon for 10 days in solitary confinement. A cruel and unusual punishment for someone not committing a crime. Recording public officials during the course of their duties is generally considered a well-established right, particularly when it comes to matters of public interest and especially when it's used for public dissemination. Jason Boyle was eventually released after an unbelievable and unjust 40 days in jail and has now filed a lawsuit.
Mr. Boyle, are you recording again?
Yes, sir.
Okay. You were advised of that, correct?
In what regard?
That you can't record at that window.
What law is that?
The order of the Chief Justice of the Supreme Court. I'm not arguing with you.
All right.
All right? You're going to be removed here in just a moment. You've been told you can't do that. All
And
right?
what law did I break?
That order, can you read English?
I don't think that's a law, because that's
Okay.
the Supreme. That's not a legislative branch, the Supreme
That's the order
Court.
of the court. I'm not arguing with you.
All right.
I'll tell you what, just have a seat and I'll be back with you in just a few minutes.
All right. Yes, thank you. How are you all?
Great.
Good. But the Supreme Court ruling is not law. Only the legislator can make law, and you guys are law enforcement. And so you guys, I do not believe, are in jurisdiction to enforce that Supreme Court order, because it's not law. It wasn't made by a legislative branch. That's why it doesn't have a law code. There's no penal code associated with that. And actually, when you read the Supreme Court opinion on that, it says that the judge may have the right to sanction me. And it's hard to say what those sanctions could be, but there's no threat of arrest that would be legal.
Interesting.
Because it's a Supreme Court ruling, right? It's not, if it was the state legislator that made the rule, certainly it would be enforceable by law. But it's not the state legislator. If we look at this ruling, it's administrative order is what it says. It's not a law.
All right, well, for right now, I'm just going to ask that you don't record next to the window until we figure out what's going on, okay?
All right, fair enough. I appreciate that. He just had it posted there. I wanted to put it on the video for the viewers. Probability of escalation is 0. Because all you have to say is, I'm going to arrest you if you don't leave, and I'll leave. And as soon as you say that, you lose qualified immunity, as you know, and it becomes more difficult.
Judge is in his office, we're just waiting for him to come back out.
We clarified that a Supreme Court ruling is not a law. And so if the Supreme Court had ruled on a case, it would follow under a legislative amendment to the law, which then would make it enforceable by law enforcement. But if you look at that administrative order, it very clearly says that in the extreme circumstance, the judge can sanction me. There's no penal code associated with that order. And so you guys are law enforcement. That is not a law, if that makes sense. And so I don't want you guys, I mean, I don't want any problems more than accountability, but the problem is at that window, they've been saying things that are inconsistent with what they say later in court. And to say that I can't document my First Amendment right to document a conversation, a private conversation between me and a public official is wrong. And so I would like to somehow challenge that to the state Supreme Court, but he has to sanction me for that to happen. You can't arrest me. And if you did threaten to arrest me, you would use your qualified immunity, in which case I would file a civil rights lawsuit against you personally. And I don't want to do that. So if you lose your qualified immunity, I can sue you in your individual capacity outside of your law enforcement profession. And so we clearly don't want that No laws have been broken. Only defiance of a Supreme Court order. It's a waste of tax dollars for him to even be calling you. He should be intelligent enough to know this has nothing to do with law enforcement. I have broken 0 laws.
What's your name, sir?
Jason Boyle.
Mr. Boyle, I'm Sergeant Sayer with Sheriff's Office. I came up a little late.
I have had interactions at this window where after the fact, the story from the judge is inconsistent with what actually occurred at the window. And so it's my First Amendment right to document any conversation like I can here with you. You're a public official, we're in public space. So I have the right to document that. And that's actually for my own security and safety.
So what brought you up here today?
They have a court summons for me. I'm coming to get served.
Oh, okay.
Someone has a court summons for me. I'm coming to get served my papers.
Do you know what it's about or anything?
Yes, I do. It's because I was in here videotaping to hold them accountable.
Okay. So you're getting summons to court for court
I have no
appearance?
idea. They came to my house. They avoided the no trespassing signs, caught my wife in the house unprepared for visitors. And then I wasn't there, so I couldn't be served. So I'm here to make sure that that Tyrant doesn't send more people back to my house illegally past no trespassing signs. I would just like to be served my papers so I can leave.
Well, typically, if a deputy had papers to serve, they would still have them, most likely.
Oh, sure. I'll
So
sit
they
right
may
here.
still not be.
Well, and you guys are all here. I mean, maybe we can call them up, get them here. They can serve me.
I can figure out who has the paper.
Yeah,
and
certainly.
see if they can
That
get
would
it.
certainly expedite processes, because once they serve me, I have no more business here. Or the recording. I'm not trying to record third parties. And if I did accidentally, I will edit them out of not because it's legal, but out of politeness. To this probate court can be a sensitive place. Something Judge Singleton doesn't understand. He thinks he's a magistrate judge.
So I
doing
talked to
criminal.
the deputy that served your papers. He served them to Dorothy.
That's not a legal service.
It is.
It is not.
Those papers are authorized for subservice. They can serve them to any adult within the household. So she has the papers. Papers have been served.
Perfect.
Okay? All right.
Excellent. Thank you all. And if you don't mind, I'll be the last to leave just because it's my standard.
Would you be willing to do me a favor?
What's that?
Instead of being the absolute last to leave, would you walk out with me? That way
Sure,
we leave
out of
together.
politeness, but I just want to say one thing. The reason that judge doesn't want me here is because he's crooked. I legally have the right to stand here. I'm not leaving by force of law, correct?
Well, that's great. I'm asking, you said you wanted to be the last to leave.
That's right.
I'm asking for a compromise.
All right, I'll take it. So
Okay.
yes, if I'm the second to last to leave, I'll take it.
We're all about compromise.
Hey, thank you guys. I do appreciate your time. I recognize that you're not the tyrant judge, that's somebody different.
Well, we're not here to debate yes or no, tyrant, not tyrant, that's not.
That's right.
We just want everybody else in the building to have a peaceful experience to the best of our ability. That's all I'm asking for, and see, just like I promised.
No, and I appreciate you guys being so polite and kind. Like I didn't know where that was gonna go, you know.
Our goal is to try to reach a peaceful resolution,
To me? Oh yeah, I'll happily come back. See where this goes.
Okay.
Hi, Mr. Boyle, would you like to delete your recording or be held in contempt of court?
I'm not deleting my recording.
Okay, all right, you're in contempt of court, you're sentenced 10 days in jail, take him into custody and take him to jail.
That I don't believe that further incarceration is appropriate. I believe that a monetary sanction or a lesser sanction is in fact a fair, equitable, and just way to dispose of this. And I would note for the court that, in South Carolina, typically, it's recognize, of course, that the court has power to hold an individual in contempt, but contempt power should be used sparingly, and contempt, insofar as it relates to a sentence of confinement, is an extreme measure, Your Honor, and I don't believe that Mr. Boyle, especially now in light of his recognition of his errors, and furthermore, that now that he's represented, he's indicated that he will have no further contact with the court or any litigants outside of what comes through counsel. And as an officer of the court, I can attest to that, and that I will make sure that my client adheres to that. Just one final thing, Your Honor. I just want to make a record real quick that Mr. Boyle does, attest that he should have been entitled to an evidentiary hearing on the previous matter. No, we're not taking that up today, but just insofar as his incarceration is concerned, we just want to make a record of that. But that has obviously no bearing on what we're here to dispose of today. And that's all I have at this time. Thank you.
All right. What stated was the first issue. That was actually the second incident, but that was direct contempt. And for the record, Mr. Boyle was given the option to turn the recorder off and delete or be held in contempt. He directly refused to do so. So therefore, it was direct contempt. You can somewhat associate the clerk's window in particular as conduct as you can in the court. Now, there's case law on that. Being that was the case, that was the direct contempt. At that time, I believe there was no monetary fine that would have settled that situation, because the situation would have been settled had he had done what the court asked him to do or give him that option, and he flatly refused to do that. That means the power of the court, whatever power the court has, the greatest power that anybody can have is know that you have that power, and yet you don't use it. That's the greatest power that anybody can have, whether it be a court or anyone else. But then again, on the other side is knowing that you have that power, and then you go through the steps to enforce it. That's what occurred, because the monetary portion would not have resolved that situation. And again, being that was brought up, that contempt was direct in nature, and the court stance is that it had the full authority to do that and hold the contempt at that time. But again, regardless, these are two separate instances, and they will be treated separately. And what happened on that particular day will not be taken into account as to what this issue of May the 24th. All right. At this time, in chambers, I discussed with you that I have two clerks to potentially testify. At this time, I'd like to call Jessica Lohman to the stand. Would you mind asking Ms. Lohman to step in, please? Ms. Lohman, if you would, please come up. Come up here, please. Place your left hand on the Bible. Raise your right hand. You swear a firm testimony about to give the whole truth, nothing but truth, so help you God.
I do.
All right, you have a seat, please. If you don't mind, would you state your name and your occupation with the court, please?
Jessica Loden and clerk of court.
On May the 24th, 2023, were you working in the court that day?
Yes, sir.
You were working at a clerk's window?
Yes, sir.
Did you have any interaction with Mr. Jason Boyle on that day?
Yes, sir.
Can you explain to the court what occurred?
He was coming in to pay for the invoice for the copies of the estate that Ms. Pierce had requested.
Okay. What if anything, did you notice that he was doing?
Recording.
Okay. Do you recall what he was recording on?
A cell phone.
Did he indicate that he was recording?
Yes.
What, if anything, did he indicate that he was going to do with the recording?
Put it on his YouTube channel.
Did he make contact with anybody else in our lobby area concerning the recording that you are aware of?
Yes, there was a female in the lobby, and he said that she wouldn't be on it whenever he uploaded it to his YouTube channel.
What, if anything, do you recall that he said to you?
Don't recall.
Don't recall. Okay. All right, Mr. Chambers, do you have any questions for this witness?
No, Your Honor.
Okay, all right, you step down, thank you. Next witness will be Maggie Bonadies, is the administrative assistant of the court. Ms. Bonadies, if you don't mind, will you come up and place your left hand on the Bible, raise your right hand, please? Do you swear or affirm testimony about to give by the whole truth and nothing but the truth, so help you God?
Yes.
All right, you have a seat, please. Could you state your name and what your occupation is here with the court?
Maggie Bonadies, I'm a court clerk and administrative assistant.
Okay, all right. On May the 24th, did you have any interaction with Mr. Boyle?
No.
Okay. Did you see or hear anything that Mr. Boyle done at that time?
Yes.
All right, what did you see or hear?
He was at the window to pay an invoice for copies. I could hear everything he was saying to Jessica. And he also mentioned to a lady out in the lobby that I was helping when he first got into the court, or the lobby. He just mentioned something about YouTube.
Okay. What, if anything, did you hear him say to the court or to Miss Lohman, Jessica?
He was talking rather fast, so it was kind of hard to keep up with it, but we took his payment. He wanted to pay in cash. He did want a receipt, and then he did say a lot about Judge Singleton.
Okay. What were the things? It's okay. You should say what you heard, and if you didn't hear anything, that's fine. Just, but what do you recall?
I recall hearing that it was a shame Oconee County allowed someone without a college degree to become a judge. That's really the only statement I recall hearing at the moment.
Okay, all right. Shortly thereafter, did you come to my office and report that to me?
Yes, Your Honor.
And what did I instruct you to do?
I wrote an affidavit and had it signed and notarized
What, if anything, did I tell you about the affidavit?
to put exactly what happened and what I remembered.
Was it stated to you not to take anything away and not add anything to it?
Yes,
Okay. Did you prepare that affidavit?
I did.
Was it properly notarized?
Yes, Your Honor.
Do you have a copy of that affidavit with you?
I do.
Anything else that you need to add?
No, Your Honor.
Okay, all right. If you don't, you have any objections, that be it submitted, I'm assuming that'd be court's number one.
No objection, Your Honor.
All right, submit that, please. We can mark that as court's number one. All right, please answer any questions that Mr. Chambers may have for you.
So you indicated that you spoke with Ms. Pierce, is that correct?
Yes.
Have you spoken with Ms. Pierce in the past?
When she's come into the office or called.
And I assume that you identified her just via the phone number that was
Yes,
calling
I
you
got it
before?
from our phone log.
Okay. And how certain are you that that was in fact Ms. Pierce that you spoke with?
100%.
Okay. And you testified that Ms. Pierce allegedly stated something along the lines of a lawsuit for the First Amendment, right? Can you tell us exactly what she said? Do you recall?
She said Mr. Bull wanted to get arrested so he could sue the First Amendment.
So those were
Those were her words.
Okay. Did Mr. Boyle make any statement while he was present in the court that he wanted to do anything of that nature?
I'm not aware of them.
Okay. And you had no direct interaction with Mr. Boyle, is that correct? So everything that you testified to, other than the call with Ms. Pierce, you kind of indirectly observed, is that correct?
Correct.
All right. Mr. Boyle, do you understand this court or no other court is hopefully going to do anything to violate your First Amendment rights or anyone else's First Amendment rights? I've done my best during my whole career to keep my character and reputation intact. Period. I am not going to allow you nor anyone else to ever take that away. I have my own family. And when I go home at night, I want to lay my head down and have a proper conscience about the things that I do. Do I like being here addressing this with you today? Absolutely not. Did I like it when I come in and seen it, and then you had the audacity Not only post it online, but here you go, send it to me in email, all right? That's like taking a needle and trying to stick it at somebody's eye, all right? Did I like it? No. Did I jump off the handle and go crazy? No. I think I'm better than that. You've indicated to some extent, I'm not going to state, you indicated that I only had a high school education. I don't know where you got that from. I'm a lay court judge with now over 25 years of experience, a total of 34 years experience between law enforcement and judicial services. I do have a college education, and I have well over 1,000 or so hours of judicial credit hours. I study, I read, I told counselors that I may not be the most best spoken person, but I just don't decide what I want to do. That's what I'm going to do for the day. I put thought and effort into it. I've worked hard to provide for my family, and for somebody like you to want to come and tear me down in the public, above being a probate judge, I'm an elected official. That is demeaning to anyone. I'm not taking it personal. I'm assuming that your fiance, whatever you call her your wife, or whatever she is to you, it appears to me that you just fall on a sword from her at the drop of a dime. That you would take that sword for her, whatever, whether she's right or wrong. Her issue will be taken care of on another day. But I'm telling you, sir, your conduct with this court is done. You've also alleged that I illegally kicked you out of this courtroom and that I later denied it. I never denied it. I will put it on the record now. What I told you on that particular day, you had this judge, regardless whether you knew who she was or not, speaking with somebody else out in our lobby. You intentionally interrupted her and told the person that she was speaking with about the proper filings of paperwork in probate court, for them not to pay attention to her, that probate court did not know what they were doing out there, and that she should come outside and talk to your wife, that your wife knew everything about probate. If your wife knew everything about probate, I guarantee you, you would not be sitting here today. Your wife would not have to be here next week if she knew everything about probate. I don't think there's anybody that absolutely knows everything about probate. I know I don't, but if my best practice, if I don't know it, I don't do it until I get the best answer. But you, sir, for you to do that, I had every right to prevent you from coming to this court. This is a public place, but I had every right to keep you out to protect other people. But I'm telling you, your conduct is enough. It is enough. And after today, it's going to end one way or another. Today, it stops. I wasn't going to bring this portion up, but I am now, because it's even more concerning to me. But yet, you have a right like anyone else, your First Amendment. There's no way that I've ever got the ability to prevent you from exercising your First Amendment right. However, I can control your conduct when you come into my court. Probate court, in any court in this state, the probate judge is elected by the people. So this is the people's court. This only judicial position in this state that's elected by the people of their county. The only position. And I refer to it as my court, being that I'm the judge of probate. I run this court. You don't, the attorneys don't, I do. Good or bad, I run the court. I've got somebody that's unruly that comes into this court, you can guarantee I'm going to take care of it, and as you know, I just did. So now you're here for the first portion of it. The thing that concerns me, Jason Bull is a man of considerable intellect integrity. His academic achievements include a PhD in chemistry and substantial postdoctoral work at the Navy Weapons Laboratory. Whatever anger issues you got, but then you done work with in a Navy Weapons Laboratory, that scares me to death. You came in twice Well, one, I think you probably knew that you shouldn't have done that to begin with, but the second time you definitely knew that you shouldn't have done that. Who's to say that the third time you don't come in with a weapon if you can't control your anger that much? Who's to say you don't do that the third time? I spoke to counsel about it, and I asked them, don't bring it up. But me seeing that you actually have assisted, helped, or done whatever with Navy weapons, I don't know what all that entails. But that is scary, and then you come in and want to intimidate and harass a court. All right, I'm a public official. I've got thick skin, that I can promise you. I've dealt with issues for years, being talked bad about, being talked good about, but I go back overall and talk about character and reputation. Regardless, at the end of the day, what you may think about me or maybe a few others, my reputation and character is intact, and it will be intact until the day I leave this office. That's a fact. That's for me to decide, not you. That there scares me. There's no doubt that you are very intelligent. Either you're very intelligent and you have no common sense, or either you're very intelligent and you got an anger issue. One or the other, maybe both, I have no idea. But your conduct with this court stops today.
Briefly, Your Honor.
Yes, sir.
If I may, in regards to his work with weapon systems, he develops weapon systems. He doesn't handle any sort of naval weapon systems. He purely,
He develops them.
he develops,
Who's to say he takes a few chemicals at home and develops one there?
and that's my point, Your Honor, just if I may, I believe that his passion overrides his common sense, and it's not more.
I may very well agree with that.
I believe that's the case, Your Honor, and as an officer of the court, I can attest to that.
Okay.
You know, I certainly believe that that's the issue, that it's not really an anger issue, it's just his passion certainly, you know, can overwhelm him at times, and it is deleterious to his common sense. Thank you.
And I have indicated previously, just to make this part of the record, it was taken up in chambers. Mr. Chambers, you came in the first day that you appeared in court. The court provided you with every document you requested. Is that correct?
That's correct, Your Honor.
I indicated the concerns I have about his boldness in approaching the court and what would occur if he come back again a third time. You go back out and say whatever you want to later on. Your First Amendment right allows you to tell a lie. If you want to go out and lie to the whole world, you can lie, okay? But you can't do it to defame somebody else with their being a public official. You just can't do that. All right, again, I've already talked about you being liable and the slanderous comments that you made. All right, conduct towards the court, attempting to intimidate a court official. These things are illegal. If it continues, then I won't have any options but to pursue those avenues. I would much rather take care of the way it's being handled today and be done with it. Mr. Chambers, do you consent that Mr. Boyle posted this video along with one prior to that? This right here was the edit of the first. I'll save some time.
Yes, Your Honor.
Do you consent that he posted those to YouTube?
I do, Your Honor.
Okay. All right. Mail of Friday, February 24th, 2024, 7:48 p.m. Thank you for including me in this conversation. What a nuisance subject. I believe the Supreme Court ruling is absolutely incorrect in accordance with the First Amendment. I recognize the challenges of addressing this discrepancy, yet I think it is worthy of clarifying the terms of the First Amendment. Here's a copy of the video. I very intentionally did not record a third party in the lobby. My contest is that you would have to justify a violation of privacy. Again, that's no violation of privacy. It was public area. It's the order of the Chief Justice of the Supreme Court. I will look forward to your reply. Thank you for this opportunity to contribute to the well-being of this great nation. If I can be helpful in any way, I'm excited to be of service. I can be present at any time. Another email, May the 28th. I am easy to find. You do not need to send the sheriff to ignore all the no trespassing signs and enter our property illegally without a warrant. If you want them to enter the private property through a no trespassing sign, they need a warrant. Let's meet in your office. Give me a date and time that works for you. I will be excited to be served in person by you. All right, for you to be excited to be served by me in person, Am I to take that as a challenge, or how am I to take that? That you would be excited to see me to receive notice?
I'm just saying that if you want to serve me, I'll happily come down.
No, but I will be excited to be served in person by you. It should have been sufficient for law enforcement to do it. I'm not a process server. I'm not a law enforcement officer. That's part of their job. Mr. Chambers, I think I'm done. I will preserve that videos for any type of appealable issues or anything further. Do you have anything else you'd like to add before I make a decision in this matter?
Briefly, Your Honor, yes, I would just like to reiterate that as Your Honor has seen today, Mr. Boyle is indeed contrite, recognize the errors of his ways, and that we would ask that you, if you find him in contempt, that a monetary fine would be appropriate, and to give him another chance, tabula rasa, to prove that he will be a man of his word, he'll delete the videos, and that he'll, in fact, have no further communications with the court. He's learned from his ways. Just give him a second chance, Your Honor. Thank you.
All right. Thank you. Mr. Chambers, like a better word, you've been somewhat of a blessing to be involved with this case or become involved with it. I believe things went much smoother today with Mr. Boyle having counsel, and for that, I appreciate it. Mr. Boyle, these are some serious issues. The day and time in which we live now, government, according to some people, government is eroding. People think they have no respect for government, no respect for rule of law. I'm required to take an oath, and I'm required to be bound by that oath. And I try to take that oath as serious as I can. I come to work, I try to provide a safe place for the employees that work here. I try to provide them with a good work experience. In general, when the public comes here, I generally try to provide them with a good experience. The majority of folks that come in here deal with grief. We understand that. People, their loved ones have died, and now they've got to go through the treacherous paperwork of trying to administer those estates. However, you got some that don't want to play by the rules. All right? And so then we have to deal with those individuals. I believe that when I was in law enforcement, Robert Kennedy once said that each community gets law enforcement to some extent, and I believe that each community should get the court that they deserve. And the fact that you come in, you're doing things the proper way, we're here to assist and do whatever we can, but if you're coming in here and misappropriation, which there's nothing's alleged in that particular state, but misappropriations, misconduct, and things like that, then you need to get the court that you deserve. Today, you're going to get the court that you deserve. I do find you in direct contempt of court. You've already served a sentence of 10 days. Court hereby sentences you to 60 days in the county jail